Welcome to From Students to Licensed Professionals, Protecting Your Rights.
Welcome to From Students to Licensed Professionals, Protecting Your Rights with attorney James Kosnett. James has represented students, parents, and families for decades, helping them navigate academic misconduct allegations, expulsions, special education disputes, and other high-stakes school issues. I'm Lisa Mosby, your host, and today we're talking about expulsion defense and what parents need to know. Thank you so much for joining me again, James.
Good to see you, Lisa.
Yeah, good to see you. Hey, when a parent first learns their child may be expelled, what is usually happening at that point, and how far along is the school in that process?
So it's a situation where usually something's happened at school, and it's not unusual to have the school question the child, sometimes for hours, in the principal's office. And sometimes they even bring the police if it's something involving weapons or drugs or a sexual harassment, physical sexual harassment kind of thing. The first thing that parents always ask me is, can they do that? Can they question my child without my being there? The answer is yes, they can. They have every right to question, and they also have the right to look in their backpack and to look in their locker because it's for the safety of the other kids and their own safety. And you give them that right when you send your kid to the school. They're like in loco parentis, so to speak. They're like in the capacity of a parent, so to speak. And so they are entitled to question. Now, the student doesn't have to answer the questions. And I always tell my clients, have the student ask for his parent. Just like if you were an adult and you were picked up by the police and they're asking your questions, what do you ask for? Your lawyer, because you're an adult. You ask for your lawyer. Well, we don't want someone under 18 asking for their lawyer. It sounds too much like they're a smart person, a smart aleck, as my mother would say, or a smart aleck. Okay. My father would say something else, but that a smart aleck. But no, don't be a wise guy. Ask for your parent and don't really make any comment. And certainly don't sign anything because they often get them to write something out and to sign it. And that makes my job so much tougher when I get involved because there's already a confession. So they say, well, they got that confession without an attorney, without their parent there. Can they use it? The answer is yes. The Miranda rights don't apply to a child in that kind of a circumstance with regard to an expulsion. They can use it against the child. So the best thing is to tell your child, look, it'd be nice if you never got into any trouble, but sometimes you get into trouble. You're in a store and one of your friends steals something and they bring you all downstairs to the basement and they question you. Sometimes you're at school, somebody accuses you of something, they take you to the principal's office, whether you did it or whether you didn't. You don't have to say anything. Be polite, be nice. Just say, please call my mom, call my dad. I really can't say anything till they're here.
Wise advice, James. Once the expulsion is being considered, what does the process actually look like from the school's side?
Okay. From the school side, the first thing they tend to do is they send the child home. It's a suspension, usually minimum the rest of the day. If it's serious enough, if it's not if it's not that serious that they're suspending them for that day, you're not going to need an attorney. I don't want you to pay money for an attorney, okay? But they suspend the child, they'll send the child home. Eventually the parent will be notified. They can suspend up to 5 days without recommending an expulsion. So They'll give you a conference, but sometimes the parents are very outraged. Oh, my child didn't do such and such, and he's being suspended or she's being suspended for this or that. Or it wasn't their fault. Yes, they were in a fight, but they didn't start it. They were just defending themselves. And I don't want a suspension on their record. Please defend me, help me, represent me. There's very little an attorney can do about a suspension. You don't really have this many rights as a parent or as a student with regard to a suspension. Think of it this way. If the teacher thought she heard you talking and she wants to keep you after school, are you entitled to an attorney? No. Are you entitled to witnesses and evidence and everything? No. If she's wrong, if it was your neighbor and she got you for it, you just pretty much got to stay after school an hour, whatever it is. That's just part of it. Not every offense and every punishment is big enough and important enough and serious enough to warrant all this due process. So a suspension up to 5 days, there's not much an attorney can do. You as the parent can go to school and argue for your child. You can make a case in the principal's office and discuss it, and perhaps you'll convince them. But it's up to the principal. It's the principal's discretion. However, if they want to suspend a child for more than 5 days, they must recommend an expulsion. Once an expulsion is recommended, that's when all your rights kick in. What do they include? Well, you have a right to an attorney. You have a right to a hearing, not immediately, but within a few weeks, you have a hearing, which is like a little trial at the district office or sometimes at the school, where there'll be a panel typically of 3 people who are neutral. They're not from that school. There might be a principal from another school or someone from the district office that doesn't really know the people involved, but some neutral, 3 neutral people who will hear the evidence and make a decision. So you're entitled to have witnesses in your defense. You're entitled to speak in your defense, or you're entitled to maintain your right to silence. The burden of proof is on the district. It's on the principal to bring to the table why he or she thinks that this child ought to be expelled, and the witnesses, the statements, the evidence, pictures, objects, perhaps a knife or a vape, okay, or some marijuana or whatever it is, whatever the evidence is, it's up to the school to present that evidence and make the case.
And James, how much time do parents typically have to respond before a hearing? And what are they expected to prepare during that period?
You usually have adequate time. Sometimes the school will give you an extension if you want it, if you need it. Usually the school will, there's no need for an extension. Usually a hearing set for a few weeks down the road. Keep in mind, the student is not going to school in that time. The student is at home. They're getting their classes perhaps online or getting assignments. In the old days, before the internet was, a teacher would actually come on a Friday, say, and give new assignments and pick up the old ones and mark them and return the marked ones and pick up new ones and so on. And that's how they'll keep the child will have his or her books at home. And but that's not a great situation for the parents. Some parents are working. There's no one to supervise the child, or it's not comfortable. So usually it's not a question of that we need more time. If we do need more time, we can ask for it. The most important thing during that time is prepare And the first thing I tell the parent is keep everyone off the internet. Don't be on social media. It always gets back to the authorities, and they always will use it against you. So don't talk to your buddies about it and what happened, and don't talk to your friends, and don't plead your case to them. Just stay off social media completely. That's very important. And obviously, don't don't go near the school. You're suspended. Don't go outside and look through the fence around the playground and call out to your buddies during recess, and you're just going to get into trouble. Don't go to the mall. The truancy police or someone's just going to pick you up. You're going to get in trouble. Just lay low, stay at home, watch TV, do a little homework, but just don't get into trouble. That's the important thing in this time.
James, what do parents tend to misunderstand about these hearings and how they actually work?
It's complicated. There's a lot that's just devoted in the education code. First of all, if it's a private school, it's completely different. You don't have the rights that a public school student has. Your only rights are in the contract between you and the private school. Now, who writes that contract? The school. And what do their lawyers do? They give their headmaster and their principal or who's ever in charge of that school, they give them complete discretion to make all the decisions and so forth. And their word is the final word. And whether or not there's meetings or hearings, they just hold all the cards. So that's a whole different category of itself. And there's a lot I can do just to get money back sometimes and to maybe either persuade them to give the kid another chance or to let the child withdraw voluntarily in lieu of being kicked out. Just like it's better to quit your job than to be fired when you're looking for another job, right? Say, no, it wasn't a good fit. I left rather than they canned me. That's not good, right? It's the same thing at school. It's better uh, if you're allowed to withdraw voluntarily. Yeah, we wasn't a good fit for us. We didn't care for it. We didn't care for the teacher and the authorities there, and so much better in catching on somewhere else, getting accepted somewhere else, looks better on your college record and so forth. Okay, so it's much better in that case. But if it's a public school, okay, the parents don't understand quite often that there's a lot we can do. We can, first of all, negotiate something in advance and avoid the hearing. Sometimes. Sometimes we can reach an agreement, for example, that we won't come back to that district and they'll let us withdraw rather than be expelled. Okay. Sometimes they'll do what's called an expulsion with suspended enforcement. Now, it's tricky because it's the same word suspended, but it doesn't have anything to do with a suspension from school. It's just like a suspended sentence, like someone who's given a jail sentence and then they're given a suspended sentence. They're not actually sent to jail. It's an expulsion with suspended enforcement. So they let you go back to school as if you're not expelled, but it's over your head. It's hanging over your head. So if you mess up again, then it would kick in. So that's something that we can negotiate. Okay. Uh, Now, there's a lot of little details in the process, and I'll talk about a few of them. One of them is that you have to get in advance all the evidence that they're going to use against you. You're entitled to that in advance. So I get that. It's called a packet, Packet, a packet of material. And when we get that, I work with the parents and the student, and we see what they've got. Often it's many statements of student witnesses, for example. Now, they're supposed to bring those witnesses to the hearing, and quite often they don't. And why don't they? Because it's inconvenient for them, because the student doesn't want to cooperate, because the parents of that student don't want them to go, and so on. So they try to use an exception which says that if they have a legitimate, reasonable fear of physical or psychological harm, they don't have to appear and testify. Now, this is really a good rule, a good law, because like for gang situations, sometimes people are afraid of retaliation. They're legitimately afraid. And so they submit a written statement and it's anonymous, and that's permitted. The trouble is that many principals and schools and districts abuse that. And they say, yes, there's a fear of retaliation when it's not a gang situation. There's no legitimate fear of the person being harmed psychologically or physically by the accused student. There's no basis for it. No threats have been made. And they just routinely use that to try to get out of bringing the student and trying to use a whole series of signed statements without bringing these people as witnesses, where, of course, if they were there as witnesses, the attorney can cross-examine them.
So, James, when you see cases where a student remains in school versus cases where the expulsion goes through, what factors usually drive the outcome?
I think it's important that we do our best to contest the evidence that's presented. Object, for example, if a situation like I just described, where there's not a live witness and there's just an anonymous declaration instead of the real person. And even when it's shown that the student did something wrong, to show that there's other means of discipline short of expulsion that are reasonable and acceptable. Has this person ever been in trouble before? Do they have a long history? Have they been suspended a number of times? Are they always getting into trouble? That's not helpful. But if they haven't, say, look, this is a first offense. Give this person another chance. Put them on probation. Keep an eye on them. Have them restrict them from extracurricular activities. If they were on a sports team, take them off the sports team, whatever, some kind of punishment, but don't expel them from the district. Don't go to the nuclear option, right? It's like expulsion is the worst punishment. Why go right to that? As educators, I tell the panel, use other tools in your toolbox to make the punishment fit the offense. What can we do to salvage this person and let them redeem themselves and earn their way back into good standing? Let's work with this child. Let's not expel the child. Expulsion is almost an admission of defeat. It's like saying, hey, there's nothing we can do with this guy. He can't be in our midst anymore. There's we for the good of everybody else, we have to expel him from our community. That should be reserved for the most serious offenses or for the most uh, incorrigible, the ones that are not getting it. They don't get it. We can't get their attention. They're in trouble again and again and again. Okay. But if it's not that situation, let's find something else, some appropriate means of correction, not letting them get away with it. There's got to be consequences, but letting them own up, letting them show responsibility, show accountability, pay the price, but continue and advance.
James, I have to say thank you for your insights today, and we'll leave it there for this episode. Well, that's it for today's episode of From Students to Licensed Professionals, Protecting Your Rights with James Kosnett. If your child is facing expulsion or another serious school disciplinary issue, we invite you to visit educationlawyer.org to learn more or schedule a free consultation. Thanks for listening, and don't forget to like, leave a review, and subscribe so you don't miss the next episode. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.